Hello, everyone. My name is Gio Nogales, and I am a paralegal here at Laos Parker. Thank you for joining us in this new webinar series with the Home Care Association of Louisiana. To get it started today, we have Dr. Warren Hebert. Dr. Warren Hebert made his first home health nursing visit in 1985 and has been a CEO of the Home Care Association of Louisiana since 1998. An assistant professor of nursing for 4 years at Loyola School of Nursing in New Orleans, and Warren is now an adjunct there and at the Rutgers Institute for Healthcare Policy and Aging Research. Dr. Hebert is on the expert panel on aging of the American Academy of Nursing.
Thank you, Gio, and welcome everyone. The Home Care Association of Louisiana is very excited to team with Laos Parker and all of the really talented folks that they have working on various legal issues. Today's presentation, Medicare Revocation, Avoiding Common Mistakes and Appealing Revocation of Your Billing Privileges. We know that many of you that are listening are folks who do some visiting in the home, and others are in a support capacity. Before we came on the air, I was sharing with Heidi that my experience with home health over decades has been a real gift from the provider perspective, but for 6 months, I had the experience of home health care, then hospice with my mother, who died in January of 2022. So to see the care experienced in the home setting from the consumer side just gives me a much deeper appreciation for the work that you all are doing. We certainly appreciate you joining us, and I understand that you're going to have a great presentation today from Ashley Morgan and Heidi Kocher. Thank you, Gio.
Yeah, no, thank you, Dr. Hebert. So like Dr. Hebert said, today's webinar is entitled Medicare Revocation, Avoiding Common Mistakes and Appealing the Revocation of the Billing Privilege. So our presenters today is Heidi Kocher and Ashley Morgan. I'm going to just do a quick bio. Attorney Heidi Kocher is a partner with the law firm at Laos Parker. She has over 20 years of experience advising and defending healthcare clients on legal and regulatory matters affecting providers of all sizes. She is an expert in all aspects of compliance and privacy programs, including developing and deploying policies, procedures, and training. Her experience includes serving as a chief compliance officer and a chief privacy officer, implementing the various requirements and aspects of corporate integrity agreements, and responding to and defending audits from Medicare, Medicaid, and private insurers up through the LLJ level. She receives her JD from Georgetown University Law Center. She is licensed in Texas and Maryland and admitted to the U.S. Court of Federal Claims. She is certified in healthcare compliance. Now, as for Attorney Ashley Morgan, she's also a partner in Laos Parker's in the DC office. Ashley focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ms. Morgan represents healthcare providers across the country in connection with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board complaints, and exclusion and termination issues. She has worked with an assortment of providers, including home health companies and hospice agencies. Ms. Morgan is also a certified professional coder, a certified medical reimbursement specialist, and a certified medical compliance officer. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, as we will address them at the end and as much as we can. So without further ado, I present to you to your speakers, Heidi Kocher and Ashley Morgan.
Thank you so much, Gio. Really appreciate it. And for the audience, I shared with Dr. Hebert that not only have I been working on the home care side professionally, but I also have dealt with home care and hospice for family members. So I happen to think home health and hospice people are saints on earth, and love doing the work that we can do to support you in all the care and kindness and love that you give to patients in the home. Next slide, please. With that said, I do have to give a little bit of a disclaimer. This webinar is presented for general information only. It does not constitute legal advice and should not be a substitute for seeking legal counsel. Again, Ashley and I are attorneys, but we're not your attorneys, and you really need to double check and provide all the facts to your attorney for a for a proper outcome. Next slide, please. So what we're going to go over is a couple of things. We're going to briefly talk about the 21 revocation reasons. We're going to talk some about the fastest paths to how to lose your Medicare number and how to avoid those. And then what if the worst happens and you actually are in receipt of a revocation letter, how to address CAPS, reconsideration, and DAB, Departmental Appeal Boards, and ALJ, Administrative Law Judge Appeals. Next slide, please. Okay, so let's get started with the 21 revocation reasons, and these all come out of the federal regulations. These are found in 42 CFR 424.535 subpart A, and if anybody wants those citations, we can go ahead and give them to you. So the first reason is that you're not in compliance with Medicare requirements as stated in the enrollment applications or in the regulations governing enrollment. And again, those are 42 CFR 424.535. And you'll see that some of these here are highlighted in red. We're going to talk about those in a little bit more detail as we go on. The second reason is that an individual or the entity is excluded or debarred from federal programs. And this can include not just the owner, but a managing employee, an authorized or delegated official, a medical director, a supervising physician, or quote unquote other healthcare personnel. The third reason is a felony conviction, and any felony in the last 10 years that Medicare determines is detrimental to the Medicare program or its beneficiaries can be a cause for revocation. The fourth major reason is false or misleading information on your enrollment application. And by the way, the approach here is that if you have omitted information, that is misstating information, so it is then therefore either false or misleading. So it is very important that your enrollment applications be completely filled out and all the fields addressed and all the questions answered. Number 5, an on-site review or other reliable evidence that the requirements are not met. These are typically failed site visits, and they're also used in conjunction with reason number 1, not in compliance with Medicare. Again, go into those in a little bit more depth. Number 6 is that you requested a hardship exception for the fee, and it was denied, and then you did not pay the fee. That's not that very common. Misuse of the billing number, which is letting another entity or individual knowingly use your billing number. Next slide, please. Slide or reason number 8 is abuse of billing privileges. And this is a pretty common one, and we'll go into this in a little bit more depth later on. One of the things to remember is this may include billing for deceased beneficiaries, that it is impossible for a provider to have rendered services. So for example, if the government can prove that the provider was, let's say, on vacation or out of the country, and yet they're billing for a date of service that would be covered or that trip, that is considered an abuse of billing privileges. Equipment not being available when the service was allegedly provided, or a pattern or practice of billing errors. And again, a pattern or practice can constitute as little as 3 billing areas or billing errors in a relatively short time frame. So things to be aware of there. Another big reason, and probably one of the biggest reasons, is failure to report location changes. This is also used here if you fail to report an adverse action relating to a failure to report a location change or a failure to report the actual change in location. Reason number 10, non-compliance with documentation requirements. This applies to written orders and certifications and so on, and including, all the documentation necessary to. Reason number 11 is home health requirement. We usually don't see that one used. Means that your billing privileges at a state level, and again, it might not necessarily be Louisiana, it could be another state, but your Medicaid billing privileges have been revoked, and then Medicare turns around and as a result, as a domino effect, revokes your Medicare billing privileges. Number 13 is a DEA certificate or state prescribing authority, suspended or revoked. 14 is improper prescribing practices. This is where CMS determines that a physician or another professional has a pattern or practice of prescribing certain drugs that fall into the categories of being abusive prescribing or a pattern that represents a threat to the health and safety of Medicare beneficiaries, or both, or the kitchen sink provision fails to meet Medicare requirements. Next slide, please. Another common reason is that you have debt, U.S. Treasury Department. 18, revoked under a different name, numerical identifier, or business identity. This is aimed at rooting out and making sure that people don't get revoked under one entity and then open up another entity and then continue with their bad behavior under another entity name or another new NPI, tax ID number, or so on. Related to that is affiliation that poses an undue risk. Again, this may be common ownership or having people who are problematic providing services at one of your locations or through one of your entities. Billing from a non-compliant location is the 20th reason for revocation. And again, that really sort of is very location specific. And finally, number 21, abusive ordering, certifying, referring, or prescribing of any Part A or B service, item, or drugs. These are all, again, found in the Code of Federal Regulations. They're elaborated on somewhat in the Medicare Enrollment Manual and the Medicare Program Integrity Manual. Next slide, please. All right, so now we're going to dive into some of the fastest paths to losing your Medicare number. And again, what we're going to do is we're going to lump these into four major buckets. The first is sort of enrollment problems as a whole, and that would include things like failure to change location, so failure to revalidate on a timely basis, failure to report an adverse legal action. The second general bucket is operational problems, and this would be things like failing to keep regular business hours, a lack of proper signage, and we'll talk about that in a little bit, or employing excluded individuals. The third bucket is billing problems. One of the prime things here is repeated high error rate claims audits. So those would your TPE, targeted provider education, or your UPIC audits. And related to the billing problem is number 4, the bucket of documentation problems, which is not just the billing and the services, the documentation for that, but also failure to keep the required paperwork for other things, such as supporting your enrollment application and so on. Next slide, please. So let's talk about the first bucket, enrollment problems. Next slide, please. As we highlighted, the reason number 5 on the list is an on-site review, or other reliable evidence that requirements have not been met. And the way this typically comes up is, number one, you have moved and CMS can't find your practice location. And there is a variety of reasons for this. One is you've moved and you didn't update your address on PAYCOS, or you didn't send in hard copy the appropriate paperwork. And so what happens is CMS goes to an old practice location, you're no longer there, and boom, they say you have an improper practice location. And again, these are usually site visits. And in conjunction with these, you often get reason number one, which is non-compliance of Medicare regulations. So that is also often cited as well. So the way you want to prevent this is, again, make sure that all of your enrollment records are up to date. One of the key things you can do is do not use a PO box or a commercial mail service like, US Mail or Post Office or Boxes R Us, that kind of thing. In any of those mailing point locations, do not use those as a practice location, because again, CMS is going to send somebody to do a site visit and they're going to walk into a retail postal boxes location and say, this isn't a home health agency, this isn't a hospice. And there you go, just for that, you're going to be revoked. So you really need to make sure you understand what your enrollment obligations are by going through the 855 and understanding what is required by each of the forms and the fields in there. The other main thing is keep copies of everything you submit. It is not uncommon for documentation to go astray. So you're going to want to use trackable mail submissions for any paper submissions. And that would be things like certified mail, return receipt requested, FedEx with a signature requirement, not just FedEx delivery, but with a signature requirement. You want to make sure you can track how the paperwork went across the country and that it got to the relevant person. If you're deciding to use PAYCOS, print the entire submission before you submit it. PAYCOS is wonderful, but things go awry there as well. Sometimes a field is, burps. Sometimes the submission doesn't work. Sometimes your internet connection drops, whatever. Make sure you print the entire submission and then, if you can, print some kind of confirmation. If you can't print a confirmation, make a note on the printed version of your electronic submission saying submitted on this date at this time by this person. You want to make sure you really track that you have done what you need to do in order to keep your enrollment records and addresses in particular up to date. And this is important because if you've updated but you can't prove that your updated information actually arrived at the contractor, you're going to lose on appeal. You can fight the revocation, but you're going to lose on appeal. So it's very important to make sure that you have the proper documentation for that. Next slide, please. So the enrollment regulations are at 42 CFR 424.510. And a couple of things here. You want to fill out all of the applications truthfully and completely. Remember that the authorized rep, whoever signs, is basically attesting that the information submitted is accurate and that the provider or supplier is aware of, number one, and number two, abides by all applicable statutes, regulations, and program instructions. By signing that attestation, you say, I understand what the requirements are, and I swear that I have fulfilled all those requirements. The second thing is to send in all of the requirement attachments, licenses, certifications, proof of the tax ID number or employer ID number, any accreditation, if you need proof of funds, if you need to send in a voided check with the EFT form, whatever it is, make sure you go through your application and you have attached and or uploaded everything that's required. The third point here is to remember that only an authorized rep may sign. This is going to be an individual who has the authority to bind the provider or supplier legally and financially to the requirements that are listed here in this CFR section. Usually this is an owner or executive. Again, you want to make sure that whoever signs it is trustworthy and honest. And the thing here too is if you're the one signing and somebody else fills out your application, make sure that you have reviewed the application and agree with all the comments, and you yourself can verify that the application is completed and all the fields have been filled in. And don't let anybody else sign for you, because it is your name and your reputation and your responsibility to make sure that all of this is completed properly. And again, that individual who completes the application is not going to be the one getting in trouble. It will be you who gets in trouble. Next slide, please. Okay, site visits. Site visits are a very stress-inducing situation for many people. They may be random, or they may be part of a pending application. And these typically are address or operational status checks only. So they're not going to pull records and do an audit and so on. This typically includes, but isn't limited to, certain aspects. And again, you need to remember that individuals who are in the moderate, let me back up a step. The screening is done on low risk, moderate risk, and high risk. Revalidating home health agencies and hospices are considered in the moderate risk screening category, and new home health agencies are in the high risk screening category. High risk also includes any supplier or provider that has been revoked and is applying for re-enrollment after the re-enrollment bar has expired. So, failure site visit equals return to go, and you do not pass go and collect your $200. If you fail your site visit, you are returning to the very start of the application process, if that's where you're at, or you will be revoked. Note that as part of this, there are also fingerprint-based background checks. These are for new home health agencies and, again, high-risk providers, and they may be done upon request. And if you get a letter from Accurate Biometrics, that is the contractor who is handling fingerprint-based background checks, make sure you understand that and, you know, be aware of that, who they are. In terms of the site visits, one of the things that we run into a lot is that somebody has failed a site visit and their Medicare number has been revoked because they have temporarily left the office. Just remember that, you know, the office, whatever it is and whatever is listed on your PACOS record, it has to be staffed and open during the posted hours of operation. So if you have to leave for an emergency, you need to put up a sign, tape a paper sign to the window saying, emergency, here's my contact information, and then put down a return time. Because what happens is if they run into an office that's closed and it looks like it might be a legitimate business office as opposed to a mailbox's site, the site visit contractor will come back 2, sometimes even 3 or 4 times to double check and see if the location is open during the posted hours. So again, for home health and hospice, this means you cannot close your doors if you are out seeing patients. You need to have some kind of, either somebody there or some kind of backup plan for illness of office staff or you being out of the office. You cannot just have the door locked and the lights turned up. off. So just be aware of that in relation to site visits. Next slide, please. So again, one of the things is the reporting obligations, and we find that a lot of people have trouble with some of the deadlines. So what we did is we've created this table here that tells you exactly what you need to report when. So for a change of ownership for Medicare, you report in 30 days. Change of control, you have 30 days. Change of authorized or delegated representative, 30 days. Final adverse legal action, 30 days if your adverse action is a federal or state license, revocation, or suspension. Otherwise, it's 90 days. Change of practice location is 90 days, and any other changes, 90 days as well. Don't forget that you also have corollary obligations at the state level. So again, your state licensing laws are going to be very important. Remember that under Louisiana law, any change of location has to be reported to the Department of Health within 24 hours of change, and that can only be within 50 miles of your current licensed location. Likewise, if you have a change of ownership, the seller must notify the Louisiana Department of Health in advance. It doesn't give a specific time frame in the statute, but you have to notify them in advance and then promptly, which usually means 30 days afterwards, after you consummate the sale and go to closing. There are, again, some particular adverse legal actions or reasons mentioned in 42 CFR 424.516, which we've noted down here at the bottom. So just be aware of those, and you know, feel free to look at the Code of Federal Regulations. It is always, always, always instructive when people read that. Next slide, please. All right, so let's talk a little bit about revalidation. Revalidation requirements are found at 42 CFR section 424.15, and you must validate upon request by CMS. And if you miss your revalidation deadline, that can result in revocation. CMS actually has put together a website with the due dates for revalidation. And so you can go onto that website. The link is here. And go to your state and put in your name, and it will tell you when your revalidation due date is. And this is updated every couple of months. I was actually on the website yesterday and noticed that some things had been updated yesterday. So I guess some of the federal government people didn't take Memorial Day off. Who knows? In any case, it is routinely updated, so make sure you check it periodically. If your revalidation is coming up within 6 months, then your organization's name will be listed and you will have a due date assigned to it. When you see that due date, make sure you promptly start working on your revalidation and submit it. If you haven't completed revalidation, you will get an email or a letter. It could be 2 to 3 months or sometimes even 3 to 4 months before the due date. Some of the pandemic things have stretched some of these things out a little bit. And again, here is where you need to make sure that your addresses and emails are up to date on your enrollment record, because if that's not up to date, you won't get the reminder letter. It'll go to another location, or it'll be returned to CMS, which then causes questions, right? Don't forget that fees apply here. Home health and hospice must pay $688 to revalidate. You can actually pay online. The link is there. And then you print the proof of payment to send with a paper application if you're doing a paper application. So, you know, a lot of times providers come to us and they say, oh my gosh, we have missed our deadlines. Don't worry. you certainly can send in an application after your deadline, and it is likely that you will be reactivated, but what you may end up having is a gap in between effective dates, and the privileges will be reactivated back to the date your application is delivered to the contractor. So again, very important that you have tracking and understand why and when something was delivered or hopefully not delivered. Hopefully it didn't get misdelivered. On this here, failure to report address changes are our #1 reason for revocations, and they're almost impossible to win unless you can prove that the application was delivered on time. When we have proof of delivery, even if it was timely, as long as that proof of delivery was before the site visit that typically generates the revocation, we can usually win, and typically very early. As a firm, we've actually taken a number of cases up to the ALJ and Departmental Appeals Board level where there was actually no proof of delivery. We won one case, but we lost others because, again, there was no proof that the application was delivered to the contractors. The ALJs are not very forgiving on this issue, and they have taken to heart CMS's argument that reporting equals delivering. So if your updates weren't delivered, you didn't report. And the ALJs are unconvinced that Medicare contractors can make mistakes, and so therefore the burden ultimately rests on you, the provider, to prove that you have sent the documentation, A, not only sent it, but B, that it was delivered. The other, one of the big reasons to fail a revalidation is failing to report a final adverse legal action. We'll talk about that a little bit more. And again, all the rest are to be reported, but typically don't result in a revocation if that reporting is done late. Next slide, please. A couple of traps for the unwary here. Use PACOS at your own risk. PACOS has its advantages, but it also has its disadvantages. Once an application is in process, the original data that you submit can change, and PACOS doesn't give users access to previous applications. This really creates a lot of problems if you're revoked and you can't access a copy of your previous application to show what you actually submitted. So if you're using PACOS, print everything off. You want to update every enrollment related to a provider or owner or managing person. And if you're sending paper applications, send them separately for each individual. Again, that way, you know, you have more of a chance of things going right. Reporting and revalidation deadline apply for the PACOS certification pages too. So make sure you properly sign the PACOS certification and submit that as well. Again, you have to be able to prove delivery before your deadline passes. So use trackable mail and print the proof of delivery. We really find that PACOS causes a lot of problems, and so we suggest you print the application again and keep a copy and upload attachments, and mail the certifications using the trackable mail, and again keep copies for your own records. Again, if you have to use United States Postal Service, send it certified mail, return receipt requested, priority mail, or express mail with signature on delivery. Same thing if you're going to use something like Federal Express, make sure you get a signature. And if you miss a deadline, send the application anyway. We often get this where individuals or providers call us saying that they've missed a deadline. Contractors have actually been instructed not to revoke an application or a Medicare number if you've already got one for missing a deadline. unless the site visit has been already attempted and failed, or unless revocation for another reason is pending. So better send it. You have a chance that you're going to be okay. Next slide, please. Ashley, you want to take it over here?
Thank you so much, Heidi. We're going to go ahead and jump into the next bucket of ways to lose your Medicare number, and this bucket is going to discuss operational problems. So let's go ahead and go on to the next slide. Okay, we're going to talk about two different issues. One is going to be, again, that on-site review. I know Heidi just talked about that issue quite a bit. But it is a big one, especially for our home health and hospice providers. So it is very important that you do understand the reasons that people get revoked for site reviews, and that does really include poor or no signage, or failure to keep your regular business hours. You're still a business. You have to operate like a business, so you need to make sure you're operating at the hours that you say you're operating. And the second reason we're going to discuss is going to be excluded or debarred from a federal program. So if a provider or supplier or any owner, managing employee, authorized or delegated individual, official, medical director, supervising physician, or other health care personnel is excluded or debarred from Medicare, Medicaid, or any of the federal health care programs, or if any of those people or entities are debarred, suspended, or otherwise excluded from participating in federal procurement or non-procurement program or activities, then you could also be revoked. And please keep in mind that I use the term managing employee. That's a pretty broad term. So you need to make sure you are screening your employees for exclusions if you are not. So let's go ahead and get into a little bit more information here. If you could go on to the next slide. So for reason number 5, again, that site reviews. Again, treat your office like a retail business. You have to be open to conduct business. Plan for emergencies. If you have somebody that is your regular receptionist that's manning the desk, what is your backup plan if that person's sick? Who's going to cover? You do also need somebody to answer the emergency contact number and return all messages timely. You need to make sure you have signage and post your hours of operation, and again, are operating during those actual hours. I will note that during COVID, we actually saw a case where a site audit was conducted remotely. This was in Alaska. It was not in Louisiana. It was in Alaska, but they tried to conduct the site audit via telephone, and the agency was not answering the telephone, and that was because they had a really busy telephone. There were a lot of people trying to call the office, and they did not have an operational message system for the site reviewer to leave a message. And so after like 3 attempts at trying to call, they were revoked for a site audit or a failed site visit because of this. Again, this was a specific instance. It was during the public health emergency. It was a tele-site visit. But it's just very important that you have some safeguards in place. If you have a phone line and you only have one receptionist, you need to make sure you have a way for people to leave messages. And you need to make sure that there is somebody at the office when you say somebody is going to be at the office that's able to accept people into the office and able to answer the phone. Because these are very difficult to reverse if you are revoked for this reason. And you won't always know that a site visit is being conducted. Sometimes they just drive by. They don't always come in and talk to you. Sometimes they'll just, come up, look around, take a few pictures and leave. So very important that you are in compliance, that you are operating day to day when you say you're going to be there. Right, let's go on to the next slide. And now we're going to talk a little bit more about reason 2 revocations, which are having an excluded party. So if you identify an excluded person, then you need to terminate or divest an excluded person within 30 days after receiving the revocation notice. And I would recommend delivering proof of that corrective action with your request for reconsideration, which is going to be your appeal. It's important that you standardize your hiring process to include checking people's licenses, doing background checks, and doing an exclusion check. I find that this piece, the exclusion piece, is what gets lost a lot of the time. You all know you have to check licenses. You all know you need to do a background check. But the exclusion piece is what kind of gets lost in the fold. So that needs to be done before you're hiring a new person. And then the federal regulations, actually the federal Medicaid regulations require, and the federal OIG recommends that you are conducting a monthly exclusion screening of the OIG LEIE, as well as all the available state lists for Medicaid. Because there's so many state lists that are available in different formats, some are in Excel, some are in PDFs, you can use a specialized agency or a contractor to conduct your exclusion screening for you. Just make sure they're doing it on a monthly basis, make sure they're checking all the lists, and make sure that you are getting confirmation each month that you did not have any matches for your employee list with their exclusion database searches. But there's still an obligation on your part to make sure you are updating your contractor with any new hires before you hire them, and that your list of employees is accurate from month to month. Because if you just provide them with one list, when you first start using a contractor, then that search is only going to be as good as that initial list. They're not going to know about those new employees. This is an ongoing obligation that you have to check. You should also, if you're thinking about acquiring a healthcare business, you should screen those employees before you actually acquire that healthcare business as a safeguard. And if you do identify somebody that is excluded, debarred, or suspended before you get a revocation notice, then you need to take proper corrective action. You need to likely terminate that person. You need to identify whether there is an overpayment that exists. Depending on the type of employee, there is specific language for how to calculate what a possible overpayment is. I would suggest consulting legal counsel if you do identify an excluded person to determine the best path forward for how to deal with any possible disclosure in regard to an excluded employee. But again, if you do get a revocation notice about this, you also need to take corrective action and will need to deliver proof of that corrective action with your reconsideration request.
Okay, let me just add here. Let me just add on the exclusions. You also should be aware that the OIG is actually running algorithms where they identify excluded individuals who might be working in healthcare providers. I've actually had a client who hired somebody and didn't realize they had been excluded under another name. And lo and behold, after that individual had been working there a few years, the entity got a letter from the OIG saying, understand that you're employing Jane Doe. She was excluded on such and such date, and you are now subject to exclusion and revocation. And oh, by the way, you owe the federal government a certain money. So be aware, you don't want to be in the position where the government tells you that you have an excluded individual. You want to be finding those people yourself.
That's right. Excellent point. Thank you, Heidi. All right. Our third bucket for ways to lose your Medicare number is going to be billing problems. So let's go ahead on to the next slide. So the reason related to revocations for billing problems is going to be reason 8, abuse of billing privileges, and specifically a pattern or practice of billing errors. So this revocation reason was actually expanded. It used to just cover impossible claims, which are the billing for dead people example, which I know that sounds crazy, but it does happen sometimes. Providers don't realize that, a beneficiary has passed, like, the day after, somebody has passed away, and if they get their dates mixed up in their billing somehow, that does happen. And that there is actually language in the Federal Register that says a provider can bill for a dead person 3 times, but on the 3rd strike you're out, just like baseball. So that used to be really the only way you would get revoked for abuse of billing privileges. And we did not see this revocation reason a lot prior to the change in the rules. But when this revocation reason was expanded to include a pattern of practice of billing errors, we have just recently actually seen a lot more action under this specific revocation reason. And we have the considerations on the slide here. CMS does retain discretion to determine whether there is a pattern or practice of billing errors. And those factors that they consider can include the percentage of claims submitted, the reason for the claim denials, history of adverse actions, length of time over which the pattern has occurred, how long the provider has been enrolled in Medicare, and my favorite reason, which is their catch-all, all other information regarding the provider or supplier's specific circumstances that CMS deems relevant to its determination. So pretty much anything else they want to consider. This is driven by data mining and audit activity by MACs and UPICs, Medicare Administrative Contractors and Unified Program Integrity Contractors. When the cases that we have seen most recently under this revocation reason, there has been a UPIC audit of a provider, and the provider has just decided to repay the overpayment amount. They did not take the case through the administrative appeals process. And actually, I've seen more than one case, and they have taken the very same, essentially, fact pattern. There's been an initial UPIC audit, provider has paid back the overpayment amount. A little while later, there's another UPIC audit. Provider sees the overpayment amount, decides the money is not worth the cost of going through an administrative appeal, or they agree with the findings and they think that their case really isn't that strong, repay the overpayment amount a second time. The problem is, if the reasons for denial from the first audit and the second audit are similar, and CMS does not see that there's been any change in the provider's documentation practice, then they're going to come back and check again. And in the cases we have seen, they've come back and checked a third time. And in those cases, we have seen them do another audit. And in the third audit, actually, we have seen them conduct a small, what we call a probe audit, and then they suspend the provider. And then they do a larger statistically valid random sample, which is essentially an extrapolation, a much larger audit. And then they revoke the provider and they assess a large extrapolated overpayment in that third UPIC audit. Really the fourth if you count the probe, but it's all essentially one time period with the probe and the SVRS. So it is critically important, if you are getting requests for documentation from a MAC, from a UPIC, from a SMRC, from any contractor, that you appeal any adverse findings. If you find that you don't have a lot of strong arguments in response, you need to make sure, if you are not appealing, that you are taking corrective action and you are documenting what that corrective action is when you take that action. So you say, we got this result from the UPIC, we did our own internal investigation, these are the steps that we took. That way, hopefully, if they come back and do another audit, your error rate will be lower and you won't really have a big overpayment or problem, and maybe you won't have a third audit. But that way, at least, if you have that documentation, you are creating a paper trail for yourself so that if you get to a third UPIC audit and you get a revocation, you have a history of corrective actions that you can point to. And these have to be real documented corrective actions, not just, putting something on paper and never putting it into practice. You actually have to carry out the work of making those changes to your documentation, updating your EMR, whatever it needs to be. So it's very, very important you are taking these audits seriously, even if the overpayment amounts are small and you don't think that the cost of taking a case through the administrative appeals process is worth the cost of, if it's going to be more expensive than the actual overpayment amount, you have to be thinking, forward and say, well, it's important for me to fight this because I don't want this to come back, 3 or 5 years from now with a revocation. So again, and if you do get revoked, there's no stay of a revocation. So you're going to get a revocation. You're not going to have any money coming in from Medicare while you're fighting that actual revocation action, and you're not just going to be likely paying for defense of a revocation. You're also going to need to be appealing the overpayment audit if it's like the cases that we have seen recently, you're going to get that revocation letter at a very similar time that you're getting the overpayment letter. So you're going to be fighting two separate appeals. You're going to be fighting an overpayment appeal, and you're going to be fighting a revocation appeal, all while you're not participating in Medicare. So you need to be taking these audits seriously, take your documentation practices seriously, and any corrective actions seriously. I think we can move on to the next slide. Just as an example, we have some language here on the slide for you that we actually have seen in recent letters. The top is from a TPE, which is a Targeted Probe and Educate result letter. It says, if after 3 rounds of TPE review, there are continued high denials, Palmetto GBA, which is a Medicare administrative contractor, will refer the provider to the Centers for Medicare and Medicaid Services for additional action, which may include 100% prepay, extrapolation, referral to a recovery auditor, etc. And then in the UPIC audit results, this is the second blurb that we have here, and specifically says, in addition, we remind you that at the regulation at 42 CFR 424-535 authorizes us to revoke Medicare billing privileges under certain conditions. In particular, we note that 42 CFR 424-535A82, CMS has the authority to revoke a currently enrolled provider or supplier's Medicare billing privileges if CMS determines that the provider or supplier has a pattern or practice of submitting claims that fail to meet Medicare requirements. So they are putting it in these letters. They are using this discretion, and CMS has a lot of discretion. So it is very important that you are taking these audits seriously, getting that documentation up to speed, training your people out in the field how to properly document the services that they're providing. So it's just a very big deal, and definitely need to make sure you're taking it seriously. And I've got a few suggestions for you on the next slide. So how can you prevent compliance and self-auditing of claims? If you identify a claim error, fix it. Do a voluntary refund. If it's within the timeline that you can still submit a corrected claim, you can do that. Talk with your compliance counsel, talk with your attorneys, and fix the claim error. If it's a one-off, you can fix it as a one-off. If it's a persistent issue, then you may need to do some other sort of corrective action, which experienced counsel can help you determine the best path forward. If you don't have a compliance program that's suitable for your business, then you need to get one, and it should include regular claim auditing. You should not just, be billing and never doing any sort of internal review of your documentation. You need to be taking that second step as well to make sure your documentation passes muster. If you're having claims denied, you need to understand why, and you need to take corrective action to reduce claim denial frequency. You need to, in conjunction with your regular claim auditing, again, train your clinical staff, provide feedback to them on their documentation. If you don't have conversations with them about issues that you're identifying in your documentation, then you're not really helping them get better. You can't expect them to get better without providing them with that feedback. So that's a really critical component. And also take a look at your ERAs. Make sure everything from your record to the claim to the ERA, does everything match up? We have seen situations where some pieces of information might get, lost in translation between the provider and the clearinghouse and Medicare. So take a look at the whole claim cycle and see if everything matches up. And again, appeal your denials. Even low dollar overpayments can become revocations if they happen repeatedly. So if you have denials that you think are incorrect, appeal those. Appeal them, and if you do have things that you think are correct, take corrective action, document your corrective action. All right, next slide. All right, and our last bucket for losing our Medicare number is documentation problems, which includes failing to keep required paperwork to support payment for services. So let's go on to the next slide. So all providers have an obligation to keep written and electronic documents, including the MPI of the physician, or when permitted, other eligible professionals who ordered, certified, referred, or prescribed the Part A or Part B services, items, or drugs relating to written orders, certifications, referrals, prescriptions, requests for Part A or Part B services, items, or drugs. How to prevent revocations for this reason? Have a compliance program suitable to your business that includes regular claim auditing, very important component. saying it's impossible or really hard is not a defense. I know if you are a home health or hospice provider, it has to rely on orders from physicians. If you're relying on getting face-to-face documentation from a provider to support, charts, I know it's very, very difficult to get that documentation because providers are very busy. You all are focused on providing care, and having to get this additional documentation is just a tedious process. But CMS is going to be looking for that documentation. They're going to expect you to have it. So saying it's impossible or really hard, that's not going to be an acceptable defense to them. So you have to get that documentation. And again, make sure your staff isn't cloning notes. All visits are unique in some way. We see a lot of denials for skilled need because the notes essentially say the same thing at every visit. So make sure that your providers are taking the time to write a brief narrative that discusses why this visit was unique. What happened specifically at this visit that stands out from the other visits? And you need to provide feedback to your staff and education on what the documentation requirements are. They cannot improve without feedback from you. That's a very important component. Okay, and so we're going to go ahead and talk about what if the worst happens. What if you receive a revocation letter? Identify the effective date. It could be before you receive the revocation letter. Certain specific revocation reasons always have, almost always, I should say, a revocation date that pre-exists the actual date of the letter. Felony convictions, site visits, excluded individuals, we see those typically are before the date of the revocation letter. That's critically important because if it's before the date of the revocation letter, then you're likely also going to get a demand letter for the period of time between the date of the felony conviction, the site visit, or excluded individuals, and the day you're receiving the letter, when you're effectively, finding out that you're revoked, because you've been billing that whole time and they're retroactively. Can we go back a slide? Thank you. They're retroactively revoking you. So you're going to have to also appeal that overpayment amount in addition to your revocation. Pretty much all of the other revocation reasons, your revocation date is going to be 30 days from the date of that revocation letter. But again, there's no stay in a revocation. So you're going to probably you will get revoked while you're pending your revocation appeal. You also are likely going to need to report the revocation to other payers or authorities like Medicaid. You likely have an obligation to report this to them. They'll also likely revoke you, not always, but typically that does follow. Private payer contracts often also require you to report a revocation, and any accrediting body, if your agency is accredited, may also require a report. All right, next slide. And I know we are coming up on our time, so I'll just make a few final points before we conclude. So now that you know everything bad that can happen, what can you do? Identify who your healthcare counsel is. Call them immediately if you receive a revocation letter. Discuss your appeal and what you can do in the meantime. This is not a time to DIY. You have 60 days from the date of a revocation letter to file a reconsideration appeal. In certain situations, you can file a corrective action plan. That's only for the 1A appeals, or A1, I'm sorry, appeals, that you can file a corrective action plan. That has to be filed within 30 days of the date of the revocation letter. So you need as much time as possible to gather evidence, because your revocation reconsideration appeal is the evidentiary deadline. So everything that you want to be considered throughout the administrative appeals process needs to be submitted with your reconsideration appeal, that first level appeal. Again, if you have an excluded person, you have 30 days after the notice of the revocation to work with your attorney to take corrective action, terminate that person, do any self-disclosure that might need to be done, and then you need to include that documentation with your appeal, and come up with a plan for how to proceed while you're revoked. Because again, you're not going to have any dollars coming in from Medicare while you're revoked and waiting to hear back on a decision. All right, next slide. So appeal procedures. So corrective action plans, I just briefly touched on that. That's only an option for non-compliance revocations. A1 revocations, those are optional. They're due within 30 days from the date you receive a revocation letter. You can't fix a failure to report, but you can address mistakes that a contractor makes, like failing to acknowledge an update you sent, and you can prove delivery. Typically, it takes 30 to 60 days to get a response back on that. For all revocations, you have the option to file the request for reconsideration. That's your first level of appeal. It's due within 60 days, or you lose your appeal rights entirely. The filing a corrective action plan does not stay the reconsideration appeal timeline. So even if you file a corrective action plan within that 30 days, you still need to file a request for reconsideration within 60 days. Again, this is the evidentiary milestone. All documentation that you want considered needs to be submitted at this level. Typically takes about 90 days to get a decision back on this. Next slide. And then if you are unsuccessful at reconsideration, you have the opportunity to file a request for review with the ALJs within the Civil Remedies Division of the Departmental Appeals Board. You have 60 days from the date of your reconsideration decision to file that appeal. This is more like a formal process. This includes briefing. An attorney is appointed to represent CMS, and you have to file briefs and enter appearances. You may request a hearing to cross-examine witnesses, but the judge can also decline. And the rules state that the ALJ should try to resolve these cases within 180 days. And I will say these cases are typically more timely than the claim appeal cases. If you're unsatisfied with the ALJ determination, you do have the opportunity to file an appeal with the appellate division of the Departmental Appeals Board. They can review that, and again, use also similar to the claim appeals, can also file an appeal in federal court if you are unsatisfied with the appellate division decision. But you have to go through all of the underlying administrative appeals prior to that. And I think that is going to do it. Do we have any questions?
So it looks like we didn't have any questions come through. So I guess that concludes today's webinar. Thank you so much to our presenters, Heidi and Ashley, for that information. And thank you to our attendees and Dr. Aber for joining us today. Just a quick reminder, I'll be sending out a copy of the PowerPoint slides tomorrow. And if you have any further questions, please reach out to them to this slide, email, or phone number. And hope to see you next Tuesday webinar.
This is Dr. Aber. I'll jump in and just want to personally thank Ashley and Heidi, and also to thank you, Gio, for helping to keep the trains running for us on time. I want to encourage any of you who are participating to reach out to Lyles Parker if questions do come up that you didn't think of during the presentation. We're so excited about the partnership with Lyles Parker, and again, Heidi, Ashley, and Gio, thank you very much.
Thank you.
Thank you.
You're welcome. We enjoyed it, and everybody have a good day.
Bye-bye.
Bye.